I'm pleased to introduce our next speaker, Shelley Brown, who is with another of our litigation firms in the city, Steinberg, Morton, Freimer. Shelley has a general practice with a particular focus on employment law, and in his practice he often comes up against the subject that we're here today trying to improve our ability to deal with it, which is how to get some early results, and particularly how to get early results on default judgment. And I certainly learned in my career that even though default judgment sounds like the easiest thing to do because you don't have an opponent, you still have to convince either a judge or a registrar to give you what you want, and it can be done. And it's just a matter of understanding you have to do that before you get started. Because if you start halfway through with your pleading saying whatever it already says, sometimes you've created an issue which you didn't need to create. So Shelley's going to help us all understand how to get the results we want through the default judgment rule 19. I'll turn it over to Shelley.
Thank you, Wendy. Actually, you put it in a very good context. And in the employment practice that I have, for the most part, I represent plaintiffs, i.e. employees who have been terminated. And given their circumstances, what you really want to do, if you can, is to get a quick turnaround. Now, hopefully you can do that through writing a demand letter and hoping that the powers that be will be fairly forthcoming and provide you with an offer fairly quickly. But more often than not, that doesn't happen. And so if you can use Rule 19 to get a quick turnaround, then you're certainly doing your client to some degree of favor. However, at the same time, there are rules that apply which more often than not allow that default judgment or noting in default to be set aside, and we'll go into that in a second. I want to make a quick reference to something which may be slightly off center and in left field when it comes to this, but I think anything that deals with surreal issues is applicable to law. And I have a quote from Lewis Carroll that I find very interesting in terms of our practice. And in it, Alice is talking to Humpty Dumpty, and they're talking about the unbirthday. I don't know if you've heard about that particular issue in Through the Looking Glass, but Humpty Dumpty says, and that shows that there are 164 days when you might get unbirthday presents. Certainly, says Alice. And only one for birthday presents, you know. There's glory for you. I don't know what you mean by glory, Alice said. Humpty Dumpty smiled contemptuously. Of course you don't, until I tell you. I meant there's a nice knockdown argument for you. But glory doesn't mean a nice knockdown argument, Alice objected. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make words mean so many different things. The question is, said Humpty Dumpty, which is to be the master, that's all. And I think it's so interesting that as lawyers, we are so often the slaves to the meaning of words as opposed to the master. Anyway, something to think about in another context. Rule 19, what I plan to do is go into the text of my topic for a period of time near the end. I will make specific reference to a couple of the cases that I quote, or at least I cite, to provide you with some of the, hopefully, an overview as to how judges have interpreted specific tests that are applicable with respect to noting, getting a default judgment as well as overturning default judgments. Rule 19 governs the procedure pertaining to defaulting defendants. However, reference should be made to the rules which govern default of parties to cross-claim, which is Rule 2807, and third-party claims, which is 2907. These rules only allow for a judgment on motion before a judge while at the trial of the main action. As well, in case-managed rules or files, Rule 7709, subparagraph 1, precludes noting a default of a defendant who has served a defense and delivered a notice of defense containing an indication that the statement of defense has been served. The rules relating to default judgments, in my opinion, are a balancing act of strict procedural rules and a desire that every party to an action has an opportunity to have their case heard. In essence, the rules are an extension of Rule 18, which imposes time limits on the delivery of a defense. Once that period has elapsed, and upon certain actions by the plaintiff or a co-defendant in certain circumstances, some serious consequences may follow to the defendant. On filing proof of service in regard to noting of default of the statement of claim, once the time prescribed in Rule 18 has elapsed, the plaintiff may require the registrar to note the defendant in default. Rule 1901, subparagraph 2, also allows a plaintiff to note a defendant in default where a defense has been struck without leave to amend, or where leave to amend has been granted and the defendant fails to deliver another defense within the time allowed. Rule 1901, subparagraph 3, also allows a co-defendant who has delivered a defense on motion to the court and on notice to the plaintiff to require the registrar to note pleadings closed if the plaintiff has failed to do so. Rule 1901-4 prohibits noting a defendant under disability to be noted in default without the leave of a judge. Rule 1902, subparagraph 1, the consequences of being noted in default. The following are fairly significant consequences and have some effect upon subsequent proceedings that you can use once you've noted a defendant in default. The defendant is deemed to admit the truth, and Wendy made reference to this in her opening remarks, of all factual allegations made in the statement of claim. The defendant is precluded without leave of the court or the plaintiff's consent to take any step in the action except to move to set aside the noting of default or any judgment that results therefrom. The plaintiff is no longer required to acquire the defendant's consent to take any step in the action which would otherwise have required such consent. And finally, except as provided in the list contained in Rule 1902-3A to P, which deals with issues of public trustee and that type of thing, no notice of any step in the action nor any document need be served on the defaulting defendant. Okay, setting aside the noting of default. It's pursuant to this rule that the court, either a judge or a master, may set aside the noting in default. It should be noted that the wording in Rule 1903-1 is identical to the wording in Rule 1908. However, notwithstanding the fact that that the wording is very similar, it would appear that the test is the same. The case of Metropolitan Toronto Condominium Corporation number 706 versus Bardmore stands for the proposition that despite the similarity in wording, the tests are really quite different. And I'll go into the 1908 test a little bit further in the paper. Or in the talk, where the failure to file a defense is explained by the defaulting defendant. So the test really in noting of a defendant in default is explanation of the failure as opposed to anything further. And you'll see that you're required to establish a valid defense when you're dealing with 1908. He or she should not be in any different position than she would be had she filed a defense, or he filed a defense. Thus, the focus is on the delay, as I've said, and not the merits of the defense. The case goes on to state that in this situation, the noting of pleadings closed should be overturned even if the explanation is questionable. If the defense is lacking in merit, the plaintiff should avail himself or herself of a motion under Rule 20. Normally, this will not be the case, and therefore an affidavit on the merits would only be required in extreme situations, and an extreme situation would be an incredibly inordinate delay. It should also be mentioned that this rule and the test it applies also appears to be applicable where a default judgment has been signed but has not yet been entered. Here in Lewis versus General Accident Insurance Company, Master Peterson has said in his reasons that until a judgment is entered, it's not considered a formal judgment, and therefore the less onerous test, as found in Rule 1903, should be applied. Signing of the default judgment. Once a defendant has been noted in default, the plaintiff may, by requisition, and again Wendy alluded to this, require that the registrar sign judgment against the defendant. These situations are limited to the following cases: either a debt or liquidated monetary demand, including interest thereon if interest has been claimed in the statement of claim, recovery of possession of land, recovery of personal property, of the possession of personal property, foreclosure, sale, or redemption in a mortgage action. The procedural requirements for the exercise of Rule 1904-1 are set out in 1904-2, and they are the following. A requisition for default judgment must be filed with the registrar, stating, firstly, that the claim is within the class of cases for which default judgment may be signed, whether partial payment has been made, setting out the date and the amount of such payment, how prejudgment interest was calculated, if prejudgment interest was included as part of the prayer for relief in the statement of claim, how prejudgment interest if it was claimed at a rate other than that, which is allowed under the rules of the Courts of Justice Act, what that rate is, and whether costs are to be fixed by the registrar or to be assessed. The case law makes it clear that the registrar has no right other than determining whether the claim is one he or she can properly sign to examine whether a real and valid dispute exists. If a defense has been filed and not struck by a judge under Rule 21, then the registrar can't sign a default judgment. So the registrar's obligations or powers within that particular rule or sub-rule are very limited, and basically it's a technicality as long as you can establish those criteria. Hassan versus 260 Wellesley Road Resident Limited stands for the proposition that I've just mentioned, and also sets out what a liquidated demand is, which is one in which the amount owing can be ascertained from the provisions of the contract, whether it's provided for expressly within the contract or where the contract directly or impliedly provides a method of calculation or fixes a scale of charges. Some examples of liquidated amounts are a claim on a guarantee where deficiency exists after asset sale or sale pursuant to a receivership, a mortgagee's claim for deficiency after power of sale, unpaid legal fees, this is important for all of us, where there had been an agreement on the hourly rate and the statement of claim states the number of hours which have been spent on the file. Where Rule 1904 does not apply, where a registrar refuses to sign judgment due to uncertainty as to whether it is appropriate to do so, or where the plaintiff decides to avail himself or herself of Rule 1905 instead of Rule 1904, the plaintiff may bring a motion for default judgment. In other words, the plaintiff has some leeway with respect to whether or not they want to have default judgment signed, as opposed to going having the registrar sign a default judgment, as opposed to going for a motion for a default judgment. The wording of Rule 1905 makes it clear that this motion must be brought before a judge. Where the claim is for liquidated damages, an affidavit is not necessary. However, affidavit evidence is required where the damages are unliquidated, for instance, a personal injury claim, damage done to property, negligence, etc., a divorce action, or a party is applying for a declaration of the invalidity of marriage. The powers of a judge pursuant to such a motion are to either grant the motion, to dismiss the action, or order a trial so that oral evidence can be adduced. Rule 1906 must be read, in my mind anyway, as an adjunct to Rule 1905, as it strikes a cautionary note for solicitors when preparing their motion materials. In essence, it suggests that undue reliance on a pleading, that being the statement of claim, may prove fatal. As a result, supporting evidence to reinforce a verbal understanding or to explain an ambiguous contractual clause should be included in an affidavit. Thus, documentation confirming an understanding or establishing that a course of conduct was undertaken without objection to the furtherance of such understanding ought to be included even though the agreement or understanding was actually alleged in the statement of claim. Again, that underpinning being that you shouldn't just rely on the fact that the allegations are admitted or deemed admitted. Rule 1906 allows the court to deny the claim if no additional evidence is brought to the table. So it's not a knee-jerk automatic right to a default judgment. There are some discretionary rights of a judge not to allow for a default judgment where there are some questionable deficiencies in the statement of claim. If no such documentation exists, an affidavit of corroborating witnesses might be of assistance. Where a trial is ordered under Rule 1905, the credibility of witnesses may be assessed by a trial judge, and in those instances, consistency, reliability of witnesses' memories, the reasonableness of inferences, etc., will be taken into account. The contents of the affidavit. While the rules do not expressly provide that warnings be provided to opposing counsel that they will be noted in default, it should be apparent to anyone who has moved for a default judgment that once a notice of intent to defend and notice of defense is delivered, judges are reluctant to grant default judgment without evidence that a final, definitive, and clearly wording warning exists that the defendant would be noted in default unless a defense was delivered within a specified time frame or by a certain date. Talk about runaway sentences. Anyway, I think that's an important sentence, though. You have to really be careful that you have set the wheels in motion and provided sufficient notice to the opposing party, to the defendant's lawyer, that you are going to, on a very specified time, within a specified time frame, note them in default. Further, although it may not be part of the court file on a motion for judgment, if a defendant has requested and been granted a reasonable indulgence, the written response to such request must be clear and unequivocal to protect the plaintiff's chances of successfully opposing a motion to set aside the default judgment. More importantly, as such motions are generally granted, this will help to ensure that the plaintiff will be awarded costs even where the defendant is successful. And also, we must be mindful of a potential motion to set aside the default judgment when we're preparing our materials for default judgment. As the motion for a default judgment is an ex parte motion or an ex parte application, full disclosures of all material facts by the plaintiff is essential. If it is determined subsequently that full disclosure has not been made, costs are put in jeopardy and may even be awarded against the plaintiff's lawyer, or well, against the plaintiff, sorry, hopefully not against the plaintiff's lawyer. In determining what ought to be included in the affidavit materials, I believe counsel should be mindful of rules 104.1 and 204.1a. Both of these rules address the inherent philosophy of the rules of procedure that, firstly, technicalities ought not to resolve legal disputes, and secondly, that as an extension of the foregoing, to the fullest and fairest extent possible, a dispute ought to be resolved, and here's a quotation mark, on its merits, as quoted in Rule 104, or as Rule 201, subparagraph 1a states, to secure the just determination of the real matters in dispute. Again, a sort of leaning towards not allowing technicalities to decide issues between parties. If there's a real dispute there, then people should allow or should be allowed their day in court. Therefore, in order to secure the goals or purposes of the rules of civil procedure as embodied by these references, judges quite appropriately are somewhat reluctant to grant a default judgment in certain circumstances. This is particularly so where a notice of intent to defend and or a request for an indulgence has been made without clear evidence that nothing more was heard of the defendant for an extended period after the filing of a notice of defense, or that there was a clear notice given to the defendant's lawyer that default proceedings would be proceeded with within a specified delay. Thus, counsel would be advised to keep these considerations in mind, as I've indicated already, in preparing their motion materials. Rule 1908, setting aside the default judgment. As indicated earlier, the wording of 1908 in regard to its remedial component is identical to that of Rule 1903. However, the test, as I also have indicated, is quite different. As a result, the materials which the defendant must produce must contain more substance than what is required merely to set aside a noting of pleadings closed. For a noting of pleadings closed, we just have to explain the default. In this one, there are several additional tests and a certain threshold that has to be achieved. One purpose of Rule 1908, which has been mentioned in several cases, is to provide an avenue whereby defendants who have a defense on the merits of an action may still have an opportunity to set the judgment aside so their case can be heard without the need to have to appeal this particular judgment to the Court of Appeal. So one of the purposes is to avoid an inundation of appeals. It allows another avenue to try and set these actions aside, or these judgments aside, sorry. It's generally accepted that there are two situations where default judgments may be set aside. Where the judgment was obtained notwithstanding that some procedure has not been correctly followed. For instance, if service were made on the wrong person. In such a case, the defendant can generally have a judgment without having to establish a valid defense. In the second instance, it's where judgment was obtained legitimately, but the court is asked to use its discretion to set the judgment aside. And the criteria are very specific, and they have to be alluded to, they have to be part of your materials. In every instance, the default must be inadvertent, and a valid explanation must be provided for that default. The motion to set aside the judgment must have been brought immediately after it becomes known to the defendant, when immediately is not rigidly applied, and we'll go into that in a second. And a valid defense on the merits has to be shown to exist. These tests were set out in the case of Chitel versus Rathbard, and I'm going to go into that in a little bit more detail in a little while. On appeal, the Court of Appeal in Chitel, because Chitel was not successful initially, stated that these tests are not to be rigidly applied by the courts. There are a multitude of cases relating to setting aside of default judgments, and I urge you to research them when you're preparing your motion materials or responding materials. But while it's difficult to provide a definitive overview, I believe that it's fair to suggest that there are two competing considerations: the length and reason for the delay, and the existence of a valid defense. With respect to the delay, the longer the delay, the more cogent must be the explanation for its length. As well, it would appear that the longer the delay, the more onerous would be the terms and conditions imposed in order to set that default judgment aside. With respect to the defense that must be established, the affidavit must disclose, at the very least, a triable issue. The case law indicates that the test to be applied in order to determine whether the judgment should be set aside is the same as that for Rule 20 applications or motions. Thus, and that's found in Hunt versus City of Brantford. Again, I'll be going into that one in a little bit more detail. Thus, where the nature of the case allows for it, one of the strongest arguments which may be used is that credibility is an issue. Further, I would suggest that a factum be delivered with the case law, asserting that the test in summary judgments applies. And these should be included in your book of authorities, obviously. Of course, the rules allow for cross-examination on the affidavit. And this is somewhat important in terms of you can go, as you know, you have certain, as a plaintiff's lawyer, you have certain equities on your side, one being that the allegations in the statement of claim are deemed to be admitted. The second is that there's a certain level of or threshold that the defendant must get to in order to get the default judgment set aside. So what you should look at very carefully, and this is a bit of a departure from the paper itself, but I think it's inherent in the paper, is what has been presented to the court in order to try and get that default judgment set aside. And if you feel that it hasn't met that threshold, you should take the following into consideration. If a defense is of questionable merit, or the defendant's affidavit contains serious errors which require cross-examinations, merely filing an affidavit in response may not be sufficient to establish to the court's satisfaction that the default judgment ought not to be set aside. But on the other side now, which is what I just alluded to, the plaintiff should be wary of conducting an extensive cross-examination on the defendant's affidavit, which is either silent on one of the elements to be proven or does not disclose sufficient elements to establish an arguable defense. Excuse me. By delving into these areas, plaintiff's counsel may be giving the defendant a second chance to establish a defense or to establish one of the other elements which may have been missing, sufficient to allow that threshold of Rule 20 to be met. As well, the case law indicates that an affidavit sworn by the defendant's solicitor is not sufficient, where it merely recounts information supplied by the defendant without independent corroboration. So be very careful about that as well. And that's found in Smith versus Old Chicopee, a 1996 case. As well, an affidavit without additional supporting evidence on the merits, or one where there is no indication of the source of the information for the belief of the merits of the defense, may not result in the setting aside of a default judgment. An overextensive or poorly conducted cross-examination may allow the defendant to overcome these deficiencies. Okay, now I'm going to go into a couple of the cases that I've already, already referred to, and perhaps go into some of the quotations that, or specific references the judges have made. Perhaps that might give us a better overview of what is necessary and what the judges look for. In Chaitel versus Rathbard, in 1982, and this is not in your materials, by the way, so it's in the cases, so you don't have to take notes, but I'm just sort of going to depart from the materials for a second. Chaitel, in 1982, initiated an action and is met with a counterclaim. In 1985, Chaitel's action is subsequently dismissed. Okay, so she no longer has an action in court. In 1986, Chaitel's counsel removes themselves as solicitors of record. In October 2nd of 1986, Chaitel fails to appear at a discovery. And as a result, Master Clark strikes the defense to the counterclaim. Okay, so this is now the counterclaim that we're dealing with. October 27th, 1986, Chaitel is noted in default. November 7th, 1986, default judgment is signed for a portion of the claim. And then on December 9th, 1986, default judgment is granted on motion by His Honor Justice O'Driscoll. Chitel then learns of this judgment. 1987, in January, Chitel retains new solicitors. March 27th, Chitel enters into and swears out an affidavit, and in April, a motion to set aside the default judgment is issued. The judgment was rendered by His Honor Justice Anderson, and it cites obviously the three elements that must be established. And at page 52 of the judgment, he then refers to an additional consideration, which I haven't mentioned in the three criteria that have to be there. This is now an added consideration by reason of the provision that affidavits may be used upon the motion for judgment. Since that is a motion made in the absence of the opposite party, there is the customary obligation on the moving party to make full disclosure of material facts. Therefore, if there have been correspondence back and forth between the solicitors whereby the defendant solicitor says, please don't note me in default unless you give me sufficient notice, etc., and sufficient notice isn't provided, that's sort of overlooked, that has to be added as part of the material disclosure. And if it's not, ultimately down the line, it may come back to haunt the plaintiff's lawyer. Then His Honor Justice Anderson refers to the threshold required regarding establishing a valid defense. The court on a motion such as this ought not to seek to determine the actual merits of the case, very similar wording to a Rule 20 summary judgment application. The fact, as alleged, must generally be accepted as being susceptible of proof, and regard in this connection must be had in the affidavit filed in the proceedings. There is no doubt in my mind that according to the test appropriate of this kind of defense on the merits, in this instance was sufficiently shown, i.e. there was a triable issue. At page 53, Anderson then comes to the conclusion that the motion was brought as soon as possible once the judgment came to Chitel's attention, that being an important aspect of one of the tests. Finally, at page 57, he then questions whether the default was sufficiently explained. He decides that as there is no clear explanation that the default in fact was not explained. There were two competing possible explanations that were given, and I'll give you a quick quote on that. It's page 57. It is simply impossible from the record to form a satisfactory conclusion as to why she, being Chitel, did not appear for examination. Whether it was because of ill health or whether it was just because she thought that the examination had been called off, it is simply impossible to form a satisfactory conclusion. The onus was on her and she has failed to satisfy it. Now I find this a little bit puzzling because from my perspective the default really should relate to the default to defend as opposed to the default to go to discoveries, but I presume that it's all being held as part of the same aspect in terms of defending your action or the action against you. Page 59, in summary, he refers to the overall purpose in this concept of having your day in court. And I'll just a very quick quote. I'm well aware of the strong disposition in our practice to resolve matters at trial and in general to relieve against technical defaults. So that's the underpinning for Rule 19, or at least for the competing interest with respect to Rule 19, because Rule 19 is very technical in nature. Question is, do we allow these technicalities to rule the day? And obviously there's a big bias leaning against that. And ultimately, at first instance, Chitel, her motion was not granted. The motion to set aside the default judgment. However, at the Court of Appeal, a year later, or within a year later, the motion was granted, and Holden, as part of the, and it looks like Alan Rock, our Minister of Health, was one of the parties here, and he was the successful party, it would appear, was one of the lawyers. In any event, it overturned that, and it basically said, unfortunately, however, Holden says, in exercising his discretion, O'Driscoll applied the rules as if they were rigid rules. This was wrong. Having found that the appellant has a defense on the merits and that the motion to set aside the judgment was brought in a reasonable time, and that the judgments amounted to almost $900,000, we are all of the opinion that notwithstanding the fact that the appellant's explanation for the delay was unsatisfactory, okay, so it actually wasn't satisfied, the learned judge should have set aside the judgments and permitted the appellant to defend the counterclaim. So again, the bias really is towards to find a way to overlook some of these issues. So all the more reason why when you're noting, when you're putting together your motion materials for default judgment, you have to be very, very, very clear. And you have to put in as much as you possibly can to try and overturn what seems to be this bias towards allowing people their day in court. And then the terms that were imposed, again, if terms will allow for some sort of redress of a long delay, that also goes into the mix. It also make it more likely that a judge will find it acceptable to overturn a default judgment. The appellant will forthwith attend for examinations. Well, that's fine. But then the appellant will, on or before September 1st, 1998, pay $27,000 to the solicitor for the respondents to be applied on account of costs thrown away. So there's a fairly onerous level of terms that are being applied in order to allow this judgment to be set aside. The second case that I would like to refer to is Hunt versus Brantford, which is also mentioned and cited in the materials. And here the solicitor for the city of Brantford, kept ignoring demands that the city file a defense. There were a series of about 3 or 4 letters from the plaintiff's solicitor saying, you know, we want your defense. We want your defense by such and such a date. Let's have your defense. And he kept basically ignoring it. Ultimately, after approximately 11 months from the service of the statement of claim, September of 92 to August of 93, the court granted Hunt a default judgment. On cross-examination at page 384 of the judgment of the reasons, it was clear that the lawyer deliberately failed to respond to the plaintiff's requests. When the solicitor was cross-examined on his lengthy affidavit filed in support of the city's motion, he stated that when he received the January 22nd, 1993 letter threatening default proceedings, he winced to himself a little, but decided not to do anything because the letter did not set a fixed deadline for delivery of the statement of defense. He went on to state that if such a fixed deadline had been set out in the letter, and if he had the impression that counsel would actually note the city in default, he would have in some manner ensured that the statement of defense was served. Well, I mean, at a certain point in time, it becomes pretty obvious that you're really risking a motion for getting for default judgment if you keep on ignoring these requests. In his mind, a fixed deadline would have converted the file into an instant and unconditional priority. In the absence of a further letter or telephone call from the plaintiff's counsel, the solicitor stated that he did not think the city would actually be noted in default. It doesn't tell how long that might have lasted, but certainly it seems to me 11 months is a fairly extended period of time. Based upon the inaction and the evidence at cross-exam, the plaintiff's lawyer claimed that the action was deliberate, okay? And that's a significant aspect of this whole thing. Is if your actions are deliberate, it's less likely that your motion to set aside a default judgment is going to be successful. And the case of Krasinski is mentioned in the materials, and basically it says here, Mr. Ballard also starts Krasinski, Mr. Ballard being the lawyer for the plaintiff, in this case the respondent. The case was a motion to set aside a default judgment, that the default of the moving parties was neither inadvertence on the part of either the plaintiffs themselves or their solicitors, but rather a deliberate decision to take a calculated risk. In my view, that is not the kind of default which the court ought to condone or relieve against, whereas here, there is no evidence of any impropriety on part of either of the responding parties or their solicitors in noting the moving parties in default or in obtaining default judgment against them. Okay, so that's cited in this particular case for the proposition that where it's deliberate and it's not inadvertent, and the other party, which is also an important component, has not acted improperly, then you should not be successful in getting your default judgment set aside. However, ultimately, in the end, the elements here are listed, that the default was unintentional. You have to provide a valid reason for the default, which apparently was not really given. The motion was launched forthwith after the judgment came to the attention, which may have been the case. A valid defense on the merit exists, which was the case. And disclosure of all material facts have been made, okay? The judge considered that in the context, while the default was intentional, so they actually made the finding the default was intentional, it was the default of the solicitor, and this is also significant and may give us some pause for comfort. It was the default of the solicitor, not the party now moving for relief under Rule 19. While no valid reason was proffered as to the default, I have to be guided by the decision in Halton, and I've made reference to that in my materials. In this respect, In so doing, I do not wish to be seen as in some way condoning the attitude taken to the matter by the solicitor. It is entirely unacceptable as it ultimately caused a great expense and delay. I'm in agreement with the submission of Mr. Cunningham that the Halton and Falzen decisions lead to the conclusion that a client should not be placed irrevocably in jeopardy as a result of the solicitor's neglect or inattention. So in that instance, the default judgment ultimately was set aside, even though it was clear that there were problems, even though it was clear that the default itself had not been explained. It was because it was the fault of the solicitor and not the client that allowed for the default judgment to be set aside. Finally, the court has a wide discretion, as we've seen, in making its determination, and although it isn't a rare occurrence for a default judgment to be upheld, the tendency is to set such judgments aside. This is so even where there have been long delays, the explanation for which is questionable, as we've seen. Where no prejudice to the plaintiff will result, and terms can be imposed where appropriate, the courts seem to be disposed in allowing litigants their day in court. Given that Rules 104 and Rule 2 directs that the rules are to be construed in a liberal manner to allow for a determination of every single proceeding on its merits, this probably is a completely appropriate determination. Thank you. Those are my...
Thanks, Shelley. I hope that when the rest of us wince, we actually do something more than just think about the fact that we might do something if someone had said something in addition to what made us wince. Thanks very much. We are right up to our schedule, so what I'm going to suggest is that we continue. And
any questions they can ask me?
Shelley, be pleased to hear from you if you have any questions. Two things I neglected to mention when we returned from the coffee break, which relate to this morning's session. I'm just going to take a minute now to do that. One of the participants in our seminar pointed out to me that they just have been involved in a matter that relates to the view of the Court of Appeal on summary judgment that was heard by a 5-panel member of the Court of Appeal. And we all know that means that the court is taking additional interest in the issues that are before the court. So I guess we'll have yet another interesting decision from the Ontario Court of Appeal on Rule 20. The other thing that one of the participants mentioned to me, which is worth mentioning, is that when we talk about the consequences of a failed motion of summary judgment, when we talk about costs, from the plaintiff's side, we also should bear in mind the more serious consequences, which is explaining to your client, having lost a motion for summary judgment, that there's no benefit to proceed to trial, which really puts a important light on the point that some people really want their day in court. And that's an additional perspective from the plaintiff's side, whereas on the defense side, you're kind of stuck with the case, you do the best you can. So you don't have that same problem. It's my pleasure this morning to introduce a distinguished member of the bench, the Honourable Mr. Justice Watt, who's sitting here in the front row beside Melissa Kennedy. As I expect most of you know, Mr. Justice Watt is a longtime and distinguished member of the Superior Court of Justice of Ontario. He's also a well-known author on law, and particularly the law of evidence. And he has written and spoken widely on a variety of different issues, not just on evidence, but on matters of both criminal and civil procedure. We're pleased to have Mr. Justice Watt come to speak to us this morning on an interesting decision from the Court of Appeal. One that's, at least in my own view, an extremely important decision, but hasn't been the subject of a lot of academic consideration. Those of us who practice litigation are very concerned about the extent to which we can properly claim privilege to govern things that we do in the course of preparing matters for trial or giving legal advice pre-litigation. And the Court of Appeal released a very important decision called General Accident Insurance, and I've never been able to pronounce the defendant's name. Maybe Mr. Justice Watt can, but Churs or something like that. In that decision, the court spoke in, I think, some fairly, in a new way, at least from my perspective, about a fairly restrictive view of some aspects of privilege. And so Mr. Justice Watt is going to comment on that case to all of our benefit, and I call upon him now.
Thanks very much. It's a pleasure to be here amongst a group of civil lawyers, which is not my usual constituency. The first civil case I tried since, or after my appointment, they sent me to Thunder Bay, which is actually further south than most people get to go, just after they're appointed. And I was told that I'd be trying some civil cases, and we start one, Waechter and Allstate Insurance, the first day, and I look up about 15 minutes into the case, and I think to myself, oh my God, the accused is not in the prisoner's box. My entire career, brief though it was at that point, flashed before my eyes, and I could see the joint address of the Senate and the House of Commons unappointing me for incompetence. And I mentioned it to the lawyers, who looked quite puzzled by it all, and said, well, my lord, this is a civil case. It's not unusual, particularly where it's an insurance company involved that we don't have anybody sitting in the box. So I feigned like I knew that, and said to them, well, would you mind just doing me a favor, though? Like, during the plaintiff's case, could you have somebody from the plaintiff's side sit in the box? And like maybe the president of the insurance company, when it's the defendant's case, could sit in the box too, so I would feel a little more comfortable and at least think that the court was properly constituted. The chances of me getting it right never got any better, but at least I felt more comfortable being wrong. The effect of a rule of privilege is to permit a party to keep from the other party and the court relevant information. These rules keep from forensic scrutiny information that may be helpful and in some cases may even be vital to an ascertainment of the truth in a piece of litigation, be it of civil or criminal nature. And rules that serve to render the accurate ascertainment of truth more difficult or even impossible may seem anomalous to a rational system of fact-finding which we think we have. It scarcely surprises then that these rules are, first of all, few in number, and secondly, strictly confined within their own borders, as the cases or the legislature or the rules committee have developed them. But the rules of privilege have their own separate rationalia, not necessarily the same for every single privilege rule, but grounded in similar considerations. They seek to protect what we consider and offer protection for what we consider to be interests and relationships that, rightly or wrongly, are regarded as of sufficient importance to justify some sacrifice of the availability of evidence relevant for a correct disposal of the piece of litigation. It does not follow from the successful assertion of a privilege, of course, that the truth will not be ascertained or the case will be wrongly decided. There are too many variables at play to justify such a sweeping statement, but to some greater or lesser extent at least, obviously depending on the importance of what is shut out to the case as a whole, the risk of error is obviously enhanced. One of the better known privileges, perhaps the one true class privilege, is the solicitor-client communication privilege. And in general terms, of course, as you know, it protects, at the instance of the client, confidential communications passing between the client and solicitor for the purpose of obtaining legal advice. The classic statement of the rule is that propounded by Professor Wigmore in the 8th volume of his work on the law of evidence in the McNaughton revision in paragraph 2292, when the editor says, where legal advice of any kind is sought from a professional legal advisor in his or her capacity as such, the communications relating to that purpose, made in confidence by the client, are at his or her instance permanently protected from disclosure by him or herself or by the legal advisor, except the protection be waived. Some argue that solicitor-client privilege is a compendious term that describes really two distinct categories or subcategories of privilege. What we might term, for want of a better description, legal advice privilege, essentially what is captured by Wigmore's formulation, and secondly, litigation privilege. It seems to me that despite the obvious relationship between the two privileges, they are discrete, founded on different rationalia, and significantly of different dimension. In the next few minutes, I'll try to explore the relationship between these two exclusionary rules, thereby to sketch out for you the borders of what, to many of us at least, is the lesser-known cousin, litigation privilege, before I examine the impact of the decision of the Court of Appeal in General Accident Insurance versus Trues. To examine the relationship between solicitor-client and litigation privilege, it's helpful to look at several factors. First of all, what's the rationale that underlies each particular privilege? Secondly, what role does confidentiality have to play in the privilege? Thirdly, is there a need for litigation to be pending or anticipated in order for the privilege to be available? Fourthly, what is the scope of the protection? Just what's covered? And lastly, what effect does the intrusion of agents or third parties have on each of the privileges? The rationale that underlies a solicitor-client privilege has to do, as you know, with the interest of all citizens in having full and ready access to legal advice. If a person cannot confide in a solicitor without fear of disclosure of what is said between them, it will be difficult, if not impossible, for that person to obtain and the solicitor to give proper, candid legal advice. Effectual legal advice can only be given if clients frankly and candidly disclose all material facts to their solicitors, and their solicitors base their opinion on those facts. There will only be such frank and candid disclosure if the client can repose in the confidence that what is said generally will not be disclosed to others. Effective legal assistance, the rationale continues, is essential to the effective operation of the legal system. The rationale that underlies solicitor-client privilege accounts for many of the limitations which we know are imposed on that privilege. For example, the requirement of confidentiality, the insistence that the communication be for the purpose of seeking or obtaining legal advice, the limitation to communications, and the exclusion of communications in furtherance of fraud or other crimes. The rationale that underlies litigation privilege, on the other hand, is really quite different. What animates that privilege is the nature of the trial process itself, the adversarial model. The court is best able to determine the truth of the matter if each side is permitted and presents its case in the strongest possible light, within, of course, the rules of substantive and adjectival law that apply. The lawyers who conduct the case must be free to make the fullest investigation and undertake the most complete research of their claim without risk that their opinions, strategies, or conclusions will be disclosed to their opponents. Advocates are required to perform their functions by using, in other words, their own wits, not making do without them, or by borrowing someone else's. Litigation privilege recognizes that there is a need for what some term a zone of privacy, a protected area, to facilitate proper investigation and preparation of the case for trial. The advocate is entitled to operate within that zone without fear that his or her activities will fund the case in opposition. To deny this protected area would be counterproductive to our current goal of early and thorough investigation of a claim, to encourage settlement, or at the very least, to encourage a narrowing of the triable issues in a case. Without it, a party might well be discouraged from anything more elaborate than the most cursory of research and perfunctory of inquiries. Why sweat it? Let the other side do the work. Like solicitor-client privilege, the rationale for litigation privilege also accounts, in some measure at least, for the limitations upon it. It does not extend, for example, beyond the litigation context because there's no need to preserve the adversarial process where one does not exist or one is not within reasonable contemplation. Solicitor-client privilege endeavors to protect a relationship. Litigation privilege has no such goal. It facilitates a process to which it is rightly confined, the litigation of competing claims. Confidentiality, as we know, is an essential element in solicitor-client privilege. There must be an intention on the part of the client to keep the communication to the solicitor confidential. Its absence is fatal to the claim, as it is to any claim of a class privilege based on Wigmore's criteria approved by the Supreme Court of Canada and Slavutich and Baker in 1976. An express assertion of confidentiality is helpful, but it's not essential, as long as the circumstances of the relationship indicate that the parties intended to keep the communication confidential. For litigation privilege, there is no requirement of confidentiality. It extends, for example, to communications which are not confidential in nature between the solicitor, for example, and third parties, as well as materials of a non-communicative nature. Litigation privilege, in other words, relates to counsel's work in assembling documents, interviewing witnesses, consulting with experts, and, in short, developing the theory, or as we call it, position, because we can't talk about theories in criminal law because they're too speculative. We talk about positions which 15 years on the bench convinces me are equally speculative. It's just that we don't call them that. Materials ingathered for the purpose of litigation may include such things as photocopies of documents not originally created in confidence, for example, public documents. Likewise, witnesses frequently make statements without any consideration or expectation of confidentiality. Nonetheless, both ingathered documents and witness statements prepared for anticipated litigation are protected by litigation privilege. Since neither ingathered document nor witness statement meets the test of confidentiality, which is, of course, a requisite for solicitor-client privilege, the fact that they fall within the ambit of litigation privilege serves to provide some evidence of the different underpinning between the two privileges. To import confidentiality as a prerequisite to establish litigation privilege is really not consistent with the rationale of the privilege itself, one that facilitates a process, not one that protects a relationship. A requirement of confidentiality really would reduce the zone of privacy to a very significant level. Essentially, the zone of privacy would be a bus stop at a street corner. We've already seen that solicitor-client privilege is established, amongst other things, where legal advice is sought from a solicitor in his or her capacity as a professional giver of legal advice. Litigation may be involved, and often is, but it's not required. The descriptive litigation privilege really tells it all. This privilege only applies in the context of litigation, actual or prospective. The protection extends, in essence, to materials brought into existence in anticipation of litigation, and the privilege is required to go no further. The need to preserve the adversary process simply does not arise outside that context. There's also a significant difference, I would suggest, in the scope of the materials that are protected from disclosure by each of the two privileges. Solicitor-client privilege protects communications only, not the facts that exist independently of the communications, which may be ordered disclosed. That is not to say, of course, that the distinction between fact and communication is otherwise than difficult to locate on occasion. But it is there nonetheless. Drawing the line too finely could seriously undermine the breadth of the privilege. In litigation privilege, there is a general principle that relevant facts contained in a litigation privilege protected document must nonetheless be disclosed on discovery, albeit not the document itself. There can be no refusal to disclose material facts solely on the ground that the only source of them, or more accurately, the only knowledge of them, is a document protected by litigation privilege. Further, again, as a general but not universal or unremitting rule, courts and rules committees have tried to strike a reasonable balance between pretrial disclosure and privilege. The animating concern really, is fairness in the trial process. It may be adversarial, but it has to be fair. Rules 31.06, sub 1 to 3, which govern the scope of examination for discovery, exemplify what some term a truncation of the privilege to achieve what is considered, by the committee at least, a reasonable balance between pretrial disclosure and privilege. Further, Rules 33.04 and 33.06 require the production of medical reports formerly covered by the litigation privilege umbrella. The scope of litigation privilege has been further curtailed by the adoption of what is called the dominant purpose test as the standard by which judges decide whether communications will attach litigation privilege. Failure to satisfy this test spells disclosure, pure and simple. In a few moments, I'll discuss the genesis of this test and how courts try to apply it. A final discrepancy between litigation and solicitor-client privilege involves the treatment of communications by a third party. Predictably, solicitor-client privilege is concerned with the role of the third party. Is she or he an agent of the client or a real third party? Was the communication made in confidence or was it otherwise? Was it made for the purpose of obtaining legal advice for the client? The agency relationship is a crucial one. Without it, the privilege will not apply. With it, and the other factors, it will. On the other hand, litigation privilege may extend to true third-party communications, provided that the dominant purpose of them is for actual or contemplated litigation. It is worth remembering when we come to determine what constitutes a person an agent, that the more expansive the definition of agent, the greater the amount of relevant and material evidence that we may keep from the trier of fact, to whom we assign the responsibility of ascertaining the truth. As a matter of policy, the definition, test, or standard that we apply should really confine agency within its narrowest scope and its proper compass. There can be no real dispute, in my respectful view, that solicitor-client privilege and litigation privilege are related. Equally, as it seems to me, they are distinct as a comparison of the underlying rationalia, the role of confidentiality, the need for litigation, the scope of the privilege, and the effect of agents or third parties on the privilege, singly or in combination, readily demonstrates. But how do they work in practice? Their relationship is exemplified, it seems to me, by the recent decision of the Court of Appeal in General Accident and Trues. The circumstances of that gave rise to claims of both solicitor-client and litigation privilege in Trues require a brief elaboration. Trues and some others owned a hotel or motel and bar property, including a licensed premises. It was insured by General Accident. On November 15th of 1994, there was a fire. It caused severe damage to the property. Immediately, General Accident retained an independent claims adjuster, B, to investigate the incident. The next day, B reported to General that the fire may have been deliberately set. Arson was suspected. Now, as a former prosecutor, suspicion of arson is not a difficult thing to figure out. Proving the case is quite another matter. Having had several vigorous but unsuccessful arson prosecutions, I'm firmly convinced, no matter how the Supreme Court of Canada defines reasonable doubt, that this week's version, last week's version, pre-correction, post-correction, we really didn't think it would affect a lot of cases, whatever version you might want to follow. The only people that you ever prove a case of arson against are the real dummies. The ones that you catch running away from the premises, sodden with an accelerant. For example, I remember as a young prosecutor being involved in a case that there was a disco, which tends to date the case, and me. Near the corner of Yonge and Bloor was a place called Momo's or Moo-Moo's or something exotic like that. And it seemed that there was a large volume of an accelerant, together with some potassium permanganate crystals, sort of spread liberally around various areas, to such an extent that if the, and this is in the cooler weather, that if the thermostat had accidentally come on, the place would have, and the corner would have gone sky high. Where I come from, Owen Sound, we would refer to that as urban redevelopment. Captured coming out of the place was a gentleman from Fire City, Buffalo. He had no identification. He had 6 $1, crisp $1 American bills in his pocket, consecutive serial numbers, and he had on a pair of gloves that happened to have a bit of funny smelling liquid on them that just happened to match the funny smelling liquid inside the premises. Surprise, surprise, he was arrested for arson. And his defense at trial was that actually he acknowledged that he broke into the premises, but he was just in there to get warm. You're going to get warm, all right. Like a marshmallow at a barbecue. And he accounted in the witness box for the first time for the material on his gloves by saying that he accidentally slipped and put his hands down on the floor, and that's how the stuff got on there. The question he found somewhat difficult to answer was how it got on the back of the gloves. So I must have put his hands down like this. He was convicted of arson. Managed to get, I think, about 12 years for his trouble, and has probably gone on to a very prospering business back in Buffalo. You can see some of his business connections on Eyewitness News. Anyway, back to Trues. As a result of the adjuster's report, General retained E, a solicitor. And the retainer was for the purpose of determining any and all issues relating to the loss occasioned to the insured premises. And the retainer included what type of strategy should be taken with respect to the proof of loss when submitted by the insured, and general legal advice on processing the claim as long as the file was open. General told the adjuster, B, to investigate the loss and to report directly to the solicitor, E. The adjuster confirmed those instructions with the solicitor, and that he was to report directly to the solicitor about the investigation. The adjuster continued with his investigation of the fire. Over a period of about 2 years, he prepared 19 reports about his findings. The first two were sent to the insurer with copies to the lawyer, and all of the rest went directly to the lawyer with no copies to the insurer. On January the 9th of 1995, Trues delivered a proof of loss. Shortly thereafter, General paid out $100,000 on the claim. Less than 10% of the amount that Trues had claimed. 3 months later, in April of 1995, General agreed to advance a further $500,000, give or take, and some payments were made on that. Then, on May the 23rd of 1995, things took a little different turn. A former employee of Trues, the general manager of the property at the time of the fire, who was later dismissed, gave a statement to the adjuster. He said that the claim was inflated. The statement was made under oath, and this employee, Pilat, also turned over a videotape. The adjuster turned over a transcript of the statement and the videotape to the lawyer. He requested confidentiality. On the 3rd of June of the same year, General commenced an action against Trues, the insured. The insurer alleged fraud, concealment, and misrepresentation. The company also sought a declaration that the policy was void. It claimed for repayment of the amount paid out and sought damages. Trues defended. He counterclaimed against the adjuster, his company, and the insurer, and initiated defamation proceedings against the former manager, Pilat. On a motion for production of documents, General claimed, first of all, solicitor-client privilege in relation to communications between its senior claims examiner and the solicitor, and between the adjuster and the solicitor, arguing that the adjuster was the insurer's agent for the purpose of communications with the lawyer. And they alternatively asserted litigation privilege in relation to communications between the adjuster and the solicitor because arson was suspected and litigation contemplated before any of these communications took place. Several important matters of general principle emerge from this decision. To begin, all members of the court recognize and acknowledge that although solicitor-client and litigation privilege may be related, they are distinct privileges founded on different rationalia. One is not a branch of the other. Secondly, litigation privilege is truncated or limited. Its full sweep cut down because of the tension between competing interests. On the one hand, the felt necessity to facilitate adversarial preparation. On the other side, the need to ensure disclosure of all relevant facts essential to a fair resolution of the dispute between the parties. Third, the modern trend is to reduce the scope of protected materials. And finally, the court adopts the dominant purpose test to determine whether documents or communications fall within the reach of litigation privilege. Is the dominant purpose behind the creation of the document or making of the communication preparing for anticipated or pending litigation, or is it something else? The court concluded that all communications between General and the solicitor were protected by solicitor-client privilege. The communications from the adjuster to the lawyer or through the insurer to the lawyer were protected by litigation privilege as long as there was a suspicion of arson, but not after the initial payment, since there was no contemplation of litigation. The communication from the adjuster to the lawyer after May 23rd, the date of the statement by the former general manager, were privileged, subject to the disclosure rules, if their dominant purpose was directed to litigation, otherwise not. And the videotape and some other documents, a float book and some timesheets produced by Pilote at the time of the statement were not subject to litigation privilege because they were not prepared for litigation. And Pilote's statement to the lawyer was subject to litigation privilege in the lawyer's hands, subject to the discovery rules. It may be helpful, just briefly, to canvass this dominant purpose test adopted by all members of the court in relation to litigation privilege. The principal source for this test is the decision of the House of Lords in Waugh and British Railways Board, a 1980 judgment. In Waugh, the plaintiff commenced an action for damages against the board under the Fatal Accidents Act. She alleged that her husband, who had been an employee of the board, had been killed in an accident that had been caused by the negligence of the board, its servants or agents. It seems to me like she had not a bad case, since the deceased died when two of the board's locomotives ran into each other. The board denied negligence. Yes, somebody else put the locomotives on the same track going in opposite directions. It alleged that the collision had been contributed to or caused by the deceased's own negligence. The plaintiff sought discovery of internal inquiry report prepared by two officers of the board 2 days after the accident. And the report was prepared, as you might expect, for two different purposes. The first one related to the operation of the railway and the safety of that operation. Typically, I suppose, so that the railway could identify the cause of the accident and take whatever steps were necessary to prevent a recurrence, or to minimize the risk, at least, of a recurrence. And secondly, the report was also prepared to obtain legal advice in anticipation of litigation. The first purpose, obviously, the internal and safety purposes, was somewhat more immediate than the second. But the evidence disclosed that they were both of equal weight or importance. Neither was, in the entire scheme of things, more important than the other. The board refused discovery on the ground of legal professional privilege. A master ordered disclosure. A single judge reversed, and his decision was upheld by a majority of the Court of Appeal. The House of Lords restored the order for disclosure. To decide whether disclosure should have been ordered, the House really had to decide in this case the nature of the connection between the preparation of the document and the anticipation of litigation, because it was faced with a document that was prepared for two purposes. One, connected with litigation. The other, not. What was the standard to be? Was it to be the sole purpose of the document, as held, for example, by a majority of the High Court of Australia in 1976 in Grant versus Downs? Was it the dominant purpose, as articulated by Chief Justice Barwick in his dissent in the High Court in Grant versus Downs, and by Lord Denning, who dissented in Waugh and British Railways Board? Or was it some other standard entirely? The House came down unanimously I might add parenthetically a concept with which we are not familiar in Canada, in favor of the dominant purpose approach, test, or standard. Lord Wilberforce put it this way at page 532 of the appeal cases report. On principle, I would think that the purpose of preparing for litigation ought to be either the sole purpose or at least the dominant purpose of it. To carry the protection further into cases where that purpose was secondary or equal with another purpose would seem to be excessive and unnecessary in the interest of encouraging truthful revelation. At the lowest, such desirability of protection as might exist in such cases is not strong enough to outweigh the need for all relevant documents to be made available. There are other passages in Lord Simon's judgment and also in the judgment of Lord Edmund Davies to a similar effect. The views of Chief Justice Barwick, dissenting in the Australian High Court in Grant versus Downs, are really where all of this comes from. And Chief Justice Barwick said, a document which was produced or brought into existence, either with the dominant purpose of its author or of the person or authority under whose direction, whether particular or general, it was produced or brought into existence, of using it or its contents in order to obtain legal advice or to conduct or aid in the conduct of litigation at the time of its production in reasonable prospect, should be privileged and excluded from inspection. So that is where the dominant purpose test comes from. That is now the test that the Court of Appeal for this province has adopted in Trues and General Accident. So what's it all mean? In the result, as it seems to me, we have, first of all, a clear separation of litigation privilege from solicitor-client privilege. It is a distinction that is fully warranted in principle. The rationale that underlies each is different. Confidentiality is essential to one, but not to the other. Litigation is critical for one, either actual or anticipated, but not the other. And the range of material that is shut out by each differs significantly. We have also now a test or standard, a gauge by which we can determine in all of the circumstances of the case whether a document prepared for purposes including but not only litigation is covered by litigation privilege. That much we know. How it plays out in a given case depends obviously on what the evidence reveals. As civil litigators are so fond of saying, govern yourselves accordingly. Thanks very much.
Thank you very much, Mr. Justice Watts. Very helpful. This concludes the morning's program. I just want to point out one change in the program for this afternoon. It's reflected in your binder, which is that at 1:30 we're going to be having the presentation on Bill 88, and the request to admit program is going to be held tomorrow. That was just a last-minute change we needed to make. I should also point out that for those of you who are not familiar with Bill 88, it has now been passed. It is now the law. It is called the Electronic Commerce Act, and it means that we now have to go to court and prove written agreements which are not on paper. And so that our first presentation this afternoon will relate to how we all go about doing that. It does not have to be, in fact, have anything to do with electronic commerce. It's an act which permits original documents to exist and never be reduced onto a piece of paper. So I look forward to seeing you. I say aye, but it will be as who's standing at the right of the room. We'll look forward to seeing you again tomorrow. Thank you for coming.